That's
both of those fact patterns, Rob, I thought should never have been brought. The claims that they were bringing were like so outlandish. Sorry, continue, but it was crazy.
This makes the point for the third leg of the stool and why premiums are going up. Because if the carrier is responsible for defending, pardon my language, all the BS cases, those BS cases, just because the way the judicial system works, some of them have to be tried all the way to the fact finder to win. And no matter how you approach it, whether it's in arbitration or in court, that can add up to a big pile of money when you're talking about the need to include forensic experts, frequently cyber security experts, IT managed services experts like yourself, all of this plus, outrageous fees that lawyers charge, all of that adds up to a big pile.
And we are rolling. Rob Scott, partner at Scott & Scott IP Law, as well as founder of Monger, an innovative platform for bringing legal services to managed service providers. More about that in a moment. We're going to be talking about something that you and I have been dealing with for about 20 years now. And this is probably one of the biggest see I told you so moments in managed services, which is, how do you survive MSP litigation? It's not how do you stop it from happening, because there's ways that we can help you stop it, but you're going to get sued if someone wants to sue you. The question is, how do you survive it? How do you win it? And Rob, you and I have been at the forefront of this battle for a long time. We're going to talk about that battle, about that campaign to educate MSPs and how to get them to a position of better safety and better preparedness for risks that they face. But thanks for coming onto the podcast and spending some time with us.
It's my pleasure to be here, Charles. Thanks for having me.
Okay, I'm going to dive right in because we're going to use every bit of our allotted time today. I can tell it. I'm going to give you two stories, two fact patterns. One is both fact patterns I think are pretty common. One may be more common to MSPs than the other, but the first fact pattern is an MSP has a falling out with their customer, managed services customer. Customer is not really happy or whatever. Just both sides don't get along. And the MSP initially says, you know what, I think maybe you ought to go find somebody else. We're not really the right MSP for you. Customer goes out and finds another provider, and then things go bad. Fingers are pointed. Accusations made. Very common scenario, many MSPs. Fact pattern 2, MSP is engaged to do project work, not with an existing managed services customer, but just a new customer. They do the project work. The customer says, you know what, you didn't do something the way we wanted to. You messed up. We had some bad things happen to us. I had a breach. We're going to hold you responsible. Little spoiler for later on. The customer had another MSP, but they go after the other project MSP. So these are two fact patterns of many fact patterns that we're now seeing. Let's start with this, Rob. What is the general state of MSP litigation today compared to where it was 15, 20 years ago?
Well, I think that, the increased risk associated with cyber attacks are really at the core of what most of these cases are focused around. If there was no cyber incident or cyber risk concern, in most of these instances, there would not be a significant claim outside of, hey, I want my credentials. You're holding my credentials hostage. We see a lot of cases involving disputes over administrative credentials in the first fact pattern that you described, where the customer is going in a different direction and they want the current MSP to provide administrative credentials. And the current MSP is saying, wait a minute, I'm not giving you the keys to the kingdom while I'm still on the hook contractually. So we wind up in these negotiations in many cases, and in some cases disputes over who owns their credentials and under what circumstances does the incumbent MSP have to give up those credentials while still being on the hook legally for bad outcomes. So that's one thing that we see a lot of today. We're also seeing things today that we didn't see 10 years ago because of the unique nature of the types of cyber liability attacks, like business email compromise, ransomware. These were not prevalent 10 years ago. And so it's the combination of the threat landscape changing, the ubiquitous nature of MSPs, and just the fact that, customers switch MSPs some frequently. And I would say the other thing is now I feel there's an emerging standard of care that I fear bad facts could make bad law around. And we've been involved in litigation where we're scratching our head at, what the implications of some of these arguments would be on the industry, like allegations that if you don't recommend certain specific tools to customers, that in and of itself is a breach of a standard of care for managed services. And so there's a number of things that are happening now that we didn't see years ago, and many of them are alarming as relates to the risk landscape for MSPs.
Yeah, I think that's a good point. I certainly don't remember. I mean, there were lawsuits. I know you did your fair share of work, 10, 15, 20 years ago with MSPs. But it certainly seems like it's accelerated. I want to hone in on what you said, which is the risk of bad law, bad precedent. There are some, admit my opinion only, there are some really crazy theories or beliefs about what MSPs ought to be doing. Could you maybe talk about some of the stuff that you and I have seen in terms of wild theories of, like, in the MSP sector, you would think, nobody believes like that. But in the outside the MSP channel community, there's some people who have wild, crazy beliefs of MSPs. What can you give me maybe a few of those anecdotes?
So despite the fact that you're the MSP and you did nothing, there's a perception that if a customer experiences a cybersecurity incident due to the criminal act of a third party, that somehow that's the MSP's responsibility to prevent those attacks in all circumstances. And if they don't, then it's up to them to pay for the damages. I think that at a high level is the underlying theme of a lot of these crazy theories.
Treating the MSP like an insurance company, basically.
Exactly.
Yeah.
Exactly. So some of the craziest things I've heard is that even though the contract that says that the MSP is not responsible for hardware, someone has a network outage due to a UPS failure, and they sue the MSP for the lost business, the time that the facility was down. A small company with 37 employees had an expert witness that argued that the failure to recommend and implement a SIEM solution, even though there was a full cybersecurity stack in place, was negligence. That an MSP who does a project to migrate files from on-prem to the cloud is responsible for a data breach that occurred after the migration, when that customer had an MSP that was responsible for putting down the security tools on all servers. And the MSP that did the project had no responsibility for cybersecurity whatsoever, was still sued in the wake of a breach. And so these cases demonstrate that there's a view among end users and their lawyers that perceives that the MSP is responsible legally for way more than what people in our industry have historically believed is the nature of the MSP relationship with the customer.
Now, I want to talk about the work that you've been doing to get MSPs to codify their relationships with customers in a formal writing, a legal contract, a legal agreement. I remember back in 2008 when the gentleman in Atlanta stood up at the conference, and you and I were on the stage and said, I still believe in doing business with a handshake, right? I'm not going to use a contract. These are these are arguments that you're presenting that try to supersede an existing agreement that states the opposite. They clearly state in both of these fact patterns you mentioned, there's an agreement that says this is what the responsibility of the MSP is. This is the argument from the opposite side, the customer side, if you will, saying, no, it's not the contract. There's a duty of care well beyond what is stated here in the contract that the MSP. That's the scary thing, I think, here.
Yeah, that's this concept that I alluded to earlier about this emerging standard of care that is prevalent in these cases, as you say. Notwithstanding a contract, they're arguing that an MSP is a trusted advisor, and they'll reach for things like that you'll do your job in a professional and workmanlike manner to read in all these other obligations that wouldn't otherwise exist. And so we've been, as you say, litigating these cases for over 2 decades. And every time we litigate one, we learn something about what we need to do in our contracts with our customers. And our customer contracts are built to address, in essence, all of the bad things that have happened to our clients over all those years. And what we've learned is that, unlike 10 years ago, there's a need to keep those agreements updated with great frequency, not less than annually. And sometimes even more frequently than that when it comes to the emerging patchwork of state privacy laws that are emerging 3 to 5 every year. And if you're doing business in those jurisdictions, there's a need for your customer contracts to update as those laws come out. And so what we've done with our Monger platform is really rethought the way we deliver legal protections to our clients. Instead of thinking of delivering them a customized template for their business, we're delivering them a hosted as a service solution that plugs into their CRM and quoting tools that we can dynamically update through the cloud.
I love it because the analogy is so powerful of, well, an MSP wouldn't wait a whole calendar year to do patching for their customers or for their internal systems, right? Saying, well, I don't need to, I'll get around to it once a year. And they somehow treat their legal agreements as being different than their antivirus or their malware definitions and patching that they do for their systems that they are responsible for. This stuff is evolving in real time. I mean, and it's global and it's quick. And that's one of the things I love about the Monger platform is that it's mimicking the technology deployment and patching of vulnerabilities in the MSP community. Not so much, Rob, I think, because of something bad that the MSPs did. But like you said before, these are arguments by the uninitiated. These are arguments of the non-MSP community thinking they know what we in our community ought to be doing. I you know me, I take umbrance at that. I think you do as well, because we've been around long enough to be saying, look, we have well-established guidelines of what we do and what we don't do.
Well, that's why I was happy in this most recent arbitration in which I was counsel for the MSP and you were the expert witness on managed services, that the arbitrator specifically pointed out that the other expert was not an expert in managed services. And I thought that was an important distinction, because you get these so-called cybersecurity experts or experts in IT professional services, and the rules of engagement and what's typical are not the same. And it's difficult for, judges, jurors, arbitrators to really understand the nuanced differences. And so over time, there will be a recognized distinction between, an expert in managed services and an expert in cybersecurity, which is not the same. And I thought that was interesting in this most recent case, that distinction was drawn, because I think it's an important distinction. We don't want to have an emerging standard of care that's developing for MSPs that has no grounding in the industry and that allows the courts and the plaintiffs to run roughshod over the risk balancing provisions that are negotiated in the contract that governs the subject matter.
That brings up a point, Rob, of settlement. And while we all like to be, idealists, right? You want to be an idealist in the legal practice that you're somehow litigating the case of the century in managed services law. And you probably have. We just don't know it yet. But there is a risk, as I see it, of quick instinct to settle a dispute, even if the MSP is in the right, simply to maybe because of insurance pressure, right? The insurance carrier is urging a cauterization of the financial expense in litigating. What can you say about that and the need to not have these wild accusations by the non-MSP community embed and become settled precedent versus settling a case?
Well, look, I think that there's always a conflict between the lawyer who wants to establish good law for all of his clients or her clients and the one client who's facing the situation and facing an uncertain economic and business outcome. And for that reason and others, it's always the client's decision when to settle. I will tell you that on more than one occasion in my career, including this past week, there are cases that get settled, pre-trial or in this instance on the courthouse steps, where it's a bittersweet outcome for the lawyer. You wait 2 years to get a case to go to trial, and now you're on the courthouse steps, and for business and other reasons, it's in the client's interest to settle. You have to push that settlement, even though for you personally and professionally, you want to go try that case and win. That's why I think it's great that the rules are so clear that it's up to the client whether to settle or not. Because if it was up to me, I would try every case that I thought I could win, even if the economics were not, or it wasn't the best business decision for the client. And that's why every client has to make their own decision. The challenge that we run into is that sometimes the cases with the worst fact pattern, with the worst agreements, are the ones that wind up going to court. So you take a case with no contract, they're going to be applying common law and tort principles to the case because there's no contract to interpret. Those cases, including the Acronis case in California, are scary.
The Sacramento case, you're talking the Sacramento law firm case.
Correct.
Yeah.
And the case that we worked on in Houston was an identical fact pattern. MSP does a project. They're not the MSP. They're in on a project. And later they get sued on the grounds that they did something wrong that resulted in a ransomware attack for a law firm. And that's just one of these things that, the contract becomes critically important. And sometimes, even with a good contract, there are arguments that can be made, and that's how you wind up in court. And when I think about getting into court, there's two things to think about that really can make it easier on you. Number one, mandatory arbitration, including consideration of expedited procedures, which doesn't wind you up in a long court battle. We have some arbitrations that are getting heard within 30 days of being set. So
fast.
Arbitration clauses, I think, are very important. And number two, cyber liability insurance to cover the defense of these claims. If any idiot with a filing fee can bring a case against you, that means you need insurance to cover the defense of those cases, even if you're going to win. The attorney's fees associated with those cases would compel you to settle those cases pre-trial, because without the defense being covered by insurance, those costs of defense could easily consume a settlement value that you could come up with early in the case. And so I think it puts you in the strongest position, both for the nuisance case and the meritorious case, to make sure that you have the appropriate cyber liability professional errors and omissions coverage that will kick in to defend you if a claim arises, such as the ones we're describing today.
Yeah, you kind of started my list of what can the MSPs begin to do to make it safe. And let's be clear, we need more MSPs. The job of the MSP should be easier to do, not more difficult. And these cases, which sound scary notwithstanding, they are winnable. they're very winnable, as you and I have seen firsthand. So number one, I think we can all agree, the first thing is to have a good airtight agreement. If you're using that circa 2000 web hosting agreement that you got at some trade show conference 10 years ago that someone put out in a template, and you just replaced your company name with the other company name, you're at risk. And so maybe the first step is, Rob talked to this point, getting a stable agreement with a master service agreement, a service attachment or a service agreement separate. And can you maybe walk through your standardized protocol or recommendation for how an MSP ought to set up these agreements?
Yeah, at the highest level, we recommend that you collapse your sales and contracting steps into one online process. So if you're using a CRM or a quoting tool, we recommend that you integrate your quote templates in those tools with an online, dynamically updated set of contracts that's modular, as you mentioned, that starts with a master services agreement that covers all the services and projects that you offer, but then includes specific service attachments for the various types of services that MSPs may offer. For example, on the Mondra platform, we have a service attachment for managed services. We have a service attachment for managed compliance. We have a service attachment for managed AI. We have a service attachment for co-managed services and a number of other ancillary services, but you get the idea. Each discrete service offering has their own service attachment of terms and conditions that are applicable. We also recommend that there's some mechanism in place to limit your liability from any act or omission of a third-party service. We call that the schedule of third-party services. And what that does is it acts as a waiver of your client's right to sue you for any act or omission of a third-party service. That's an important part of the contract.
So stop you right there. I call that the Microsoft clause, right? The Microsoft clause, which is, Microsoft says, we're not responsible for anything. It's all on you. Don't even look at us in our direction. We're not going to make you whole again. If something bad happens with Microsoft, your theory is what? There's a good way that you put it. I'm going to let you say it. But
if something happens with Microsoft, under the terms of our schedule of third-party services, it says that the MSP is not responsible for any act, omission, or failure of a third-party service. And under these circumstances, Microsoft would be a third-party service provider under our schedule of third-party services with that waiver. So regardless of what the MSP's agreement says with Microsoft, the MSP is entering into an agreement with its customer that says the customer understands and acknowledges that if Microsoft has a data breach and the MSP is reselling 365, that it's not going to be the insurance company for Microsoft.
Because the customer should not be in a better position to be compensated because they have an MSP who is vulnerable, where they should be in the same position as if they had been going direct to Microsoft. Is essentially
I
what you're
think
saying.
that's an important point for the MSPs to really focus on if their customers push back on this concept. It's like, if I wasn't selling you this Microsoft license, you could buy it from someone else or you could get it direct. If I wasn't coordinating all these vendors and bringing this curated tech stack to your company, you'd have to go out and contract with these vendors directly. And those agreements would say that those vendors are not going to be responsible. So why would I put you in a better position vis-a-vis the risk of using these vendors that you're going to need either way? Why should the MSP be bringing a greater risk reduction? Because it's not an insurance company. That's an insurance company role.
Huge point, folks. If you should put that last statement on loop, make it into your company answering machine, because that should be something that everybody just listens to every single day. It's so critical. Rob, I'm going to talk about transition services, because this is something that came up. We saw this firsthand. How are you advising MSPs to handle via contract, via writing, a common occurrence that almost every MSP has probably witnessed at least once or are witnessing either I would hope that the MSPs listening to this are the beneficiaries of this, but maybe they've lost a few, or maybe they've fired a few. How you handle a transition out or in agreement with a customer?
I think number one, it's critically important to exclude any transition services from the base managed services contract.
Treat it like a project.
It's a project, and it's only going to be quoted and offered to somebody who's in compliance with all the terms, including the payment of any early termination fee. So number one, it's above scope for any agreement that's in place. Number two, it's at the election of the MSP and at their then prevailing rate. And it's only available to customers who are in compliance with all the terms and conditions, including the payment of the early termination fee. Once you establish that framework, then there are some questions about credentials and the nature of the transition services that are available. In the case that we litigated, that you referred to, the customer demanded not only their credentials, they demanded global admin credentials for platforms that our client was the reseller on, and they demanded credentials for multi-tenanted platforms that our clients were managing for the benefit of that unique customer, but access to which would have given them access to all of the MSP's customers. So one of the most recent changes that we've made to our agreements as a result of that litigation that just ended is a whole section around definition of credentials. And this is importantly related to transition services. If you need to transition, your credentials are yours. These are user credentials. We don't manage them. We don't own them. We don't want to know them, and we will never keep them from you. And with your user credentials, you should be able to do anything you need to do to gain access, to run the business, to do transactions, right? Then there's the admin credentials. These are the customer's administrative credentials used by the MSP to manage the customer's environment. The customer could get those credentials from the MSP, provided that it alleviates the MSP from any further obligations under the contract, and provided that it's in compliance with all of the terms, including the early termination fee.
Yeah,
and the last category is third-party credentials, which you will never get. They don't belong to you. We can't give them to you. And we're never going to give them to you. If you want...
For example, what would those be?
Duo, Datto, any of the platforms that the MSP uses, RMM platforms, Kaseya, ConnectWise, any third-party platforms that are in the MSP's tech stack, they never get those credentials. And if the client wants to migrate, then it needs to follow the procedures of the vendor and make sure that a new partner is assigned to take over the matter, but they're never getting their credentials from the MSP. So those are the categories that we have incorporated into the agreements recently as a result of this case where the dispute was over transition services.
Right. So for those listening at home and toiling hopefully in horror at the notion that there's a universe out there where a customer actually thinks that they have the right to gain access to your administrator account for your RMM or your ticketing or your backup solution, you're in this universe with us. And I like the fact, Rob, that you've now codified that into your standard Monjur agreements. This is codified into the UCS, right? These are not just the UCS, but many control frameworks across the world do tangentially prohibit or discourage that type of behavior, but they nevertheless made it in a legal proceeding and said, we want access to that as if it was a normal thing.
Yeah, and as if the failure to do it is somehow sinister.
That was the claim as well. Yeah, you're right.
Yeah.
You're right. Okay. So transition services, transition events, really critical for you as MSPs to have that contractually handled. Rob just gave you a very crystal clear methodology for how to deal with that. That's like sales 101. That's like service delivery 101, and it's legal 101, all wrapped up into one. It's really good. If you're not doing something like that, you should start today. So, Rob, we talked about your contract approach. We've talked about transition services. Let's talk about insurance. Insurance is really touchy. You and I write a book probably on managed services insurance. There's a lot of disgruntled MSPs out there who are sick and tired of getting their insurance premiums for cyber coverage increased or their coverage being dropped, many of whom don't even have a claim, right, to speak of. And so they're really baffled. What's the role of MSP insurance today? You mentioned one of those, which is coverage of litigating these types of crazy claims. What else is there?
Look, I think that the most prevalent insurance policies that MSP use are a variation of a tech media type coverage that covers both professional acts and network security and data privacy incidents, as well as issues that would arise as a result of any negligence in the performance of or injuries that arise among customers in connection with the services being offered under a contract. This is called professional liability. Some call it cyber liability, but this is errors and omissions or malpractice type insurance for MSPs. And we recommend to all of our clients that they get it. And it's part of our standard onboarding to confirm that the MSPs have the insurance that's an appropriate, fit for what we express in our contracts. The difference, Charles, is that in 2008, when we first launched managed services professional liability with Lloyd's of London for the MSP Alliance, the MSPs were telling us, nobody knows what we do. Nobody can write anything for us. And there's just really no availability. Like the product was hard to come by.
It was early. It was definitely early.
Fast forward today, the product is offered by many major carriers, but they've been spooked by what they call aggregated risk. Aggregated risk refers to a concept that the insurance company has articulated, or the industry, around MSPs, because a bad actor theoretically could infiltrate one MSP and create damages for hundreds of their customers. And so because of that, many carriers have become reluctant to write coverage. Many have exited. And while there's still a robust market, affordability and availability are still two huge concerns. The premium cost is a reflection of the number of incidents, the prevalence of ransomware and business email compromise and other cyber attacks. The claims history is such that there's a driving of rates, and these cases are very expensive to defend. Even you've seen firsthand, Charles, in the cases where you've served as an expert witness, where I was counsel for the MSP, these cases are hard fought. Lots of lawyers involved, lots of expenses, very time consuming. And even when you win, sometimes the client doesn't feel like they won because they got an award that said they won the case, but their bank account says they lost. And that's really where the MSP specific professional liability insurance really comes in. It's going to protect you. It gives you a way to anchor your risk balancing provisions in your customer contracts to the insurance, to create insurance as the primary risk transfer so that the customer knows they're protected to an extent subject to a cap so that the MSP is not exposed over the amount that they've transferred for insurance. And so used correctly, it creates an elegant way to share risk between the MSP and the customer. And so I'm a huge fan of using professional liability insurance. That being said, I want there to be lower cost options. I want it to be more available. I want MSPs who follow best practices to be rated differently than the average MSP. I want MSPs that have great contracts and are using control frameworks to demonstrate their adherence to the standard of care, to get lower rates, to have more availability options. So I still have all those goals, but in the meantime, I think it's important for MSPs to secure cyber liability coverage, professional E&O coverage, and to use it as the primary risk transfer mechanism in their customer contracts.
So I wholeheartedly agree with that. I still believe in insurance as a third leg of that MSP risk stool, right? Insurance, agreements, compliance or certification, whatever you want to call it, for internal controls. That aggregated risk, I think, comes from aggregated ignorance, right? A lot of these, like I always wondered why these rates are going up. And now I see, because they're insuring companies that come up with these crazy ideas like the customer is actually obligated to get the MSP's global admin accounts for all their RMM, MSP tools, right? Not that that's actually ever been successfully litigated, but the fact that people think about it and bring it up in a legal proceeding is enough to tell me that there's a lot of misinformation out there. So I would say this, Rob, and let me know what you think about this, because I know a lot of MSPs who are foregoing insurance, or they're at least cutting out or lowering their cyber coverage. Good or bad, that I'm hearing that, right, because of the just sheer cost and availability issue. I think having solid agreements could be at least the bare minimum of what you need in order to scare off, along with the well-established documented controls, let's say through a certification that would prove and evidence the fact that you're actually doing things the right way. The contract sets out the legal obligation between the MSP and the customer. Would that be enough? I guess, can it be enough to say, look, you're not going to prevail in litigation with anyone who would attempt to break down that responsibility?
Yeah, look, I think that you want your contracts to be so robust that when your customer goes to a competent attorney and says, do we have a case? The answer is no. So we want to make sure that your contracts cover all the angles as much as possible so that it deters the filing of the case in the first place. And those that fall through the cracks and get filed anyway, those are the ones that we're going to rely on the evidence associated with certification and compliance to establish that you did nothing wrong. And we're going to rely on the insurance to make sure that you don't have a catastrophic financial outcome merely in defending a claim that you should never have been brought against you in the first place. And so that's
both of those fact patterns, Rob, I thought should never have been brought. The claims that they were bringing were like so outlandish. Sorry, continue, but it was crazy.
This makes the point for the third leg of the stool and why premiums are going up. Because if the carrier is responsible for defending, pardon my language, all the BS cases, those BS cases, just because the way the judicial system works, some of them have to be tried all the way to the fact finder to win. And no matter how you approach it, whether it's in arbitration or in court, that can add up to a big pile of money when you're talking about the need to include forensic experts, frequently cyber security experts, IT managed services experts like yourself, all of this plus, outrageous fees that lawyers charge. All of that adds up to a big pile. And even if you're in the right, and even if it's a case that should have never been brought, you're still stuck with that defense if you don't have the insurance.
Well, Rob, maybe for the next episode, you and I can come on and come up with a revolutionary new way to lower MSP risk, and that'll upend the existing methodology and turn everything on its head. Maybe it's time again. What do you think?
Well, look, I think that this is an issue that we've been dealing with since before '08. We've had a vision for how to protect MSPs from these risks since that time. And through decades of hard work, if anyone can figure it out, it should be us.
I think we got some good ideas running. So just to recap, get your contracts reviewed. Go over to Monjur, monjur.com. Is that right?
That's correct.
Monjur.com. Talk to Rob. Get your contracts sorted out. Make sure that your gaps, your flanks are protected legally. Get certified. Make sure you can keep your insurance. By the way, if you're certified and you have these good contracts, you should have a really good case for getting a lower premium. We'll talk about that in the next episode. But You need this stuff in place, because if you have a crazy client that comes at you, like some of these that Rob and I have been talking about, you need to be in a defensible position to not just survive, but to win. Right. And I think that that's really critical. These are winnable. Rob, that's the one thing that I took away, is that there's some hope left for the legal system, or at least the arbitration community, that these are winnable fact patterns.
There's no doubt that the challenge is that sometimes the economics get in the way of justice. Not sometimes, frequently.
That's always been the case.
Yeah. And but as the amounts in controversy get lower and the cost to litigate go higher, more and more cases are just not suitable for the justice system because of the delta between the amount in controversy and the cost of pursuing. And so that's why the contracts are so important. That's why the certification and the compliance is so important. And that's why the insurance is so important. And with those three legs of the stool, as you describe it, we put the MSP in the strongest position to not only mitigate risk associated with a case ever being filed, but putting them in the strongest position to win not only on the merits, but financially because of the coverage of the defense.
So, couldn't have ended it in a better way. I propose, Rob, we move these to later in the day so we can bring out the Yamazaki and the what's your
I like the Ronza Kappa 23 is probably my go-to.
Ronza Kappa. All right,
not my favorite, but it's my go-to because it's got the best combination of availability, price, and quality, and it's a Guatemalan rum. One thing I love about collecting rum is they make rum all over the world. Tequila comes from Mexico. Rum comes from everywhere.
I hadn't thought about it that way. I suppose that's true. Yeah. All right.
I have a pretty good tequila collection as well.
Until next time, and we'll have you back soon, I hope, Rob, to talk about some of these additional cases that you're working on, and updates on lowering MSP risk. It's a huge important topic, but rest assured, we're on it. We're going to come up with a solution soon. Until next time.
Thank you so much. Thank you, Charlie. I appreciate you. Look forward to seeing you again soon.